Hi,
I want to introduce Linda Grims. Linda's our lead counsel she works at DOJ, but she's lead counsel for the DHS and also the Oregon Health Authority. So extremely knowledgeable lawyer, and she offered to come over with me, drove me over. I do apologize for the slight modification of our schedule. It just turned out to be one of those kind of wild days, but really, really happy to be here, and thank you for accommodating that.
Well, we really appreciate you fitting us in. Things come up. But yeah, I guess we'll officially get the meeting underway here. First thing, we have about 15 minutes less than we anticipated, so maybe we'll do some very quick introductions, starting with Jim.
So I'm Jim Clark, and I'm the ACMM since its inception.
Alice Ivany. Sandy Burbank.
I'm Brian Michaels, attorney from Eugene. And can I just get Linda's last name?
My name?
Yes.
Grims, G-R-I-M-M-S.
Thank you.
Sure.
And I'm Todd Delato, the ACMM chair, and I also the Horticulture Research and Safety Committee chair, and I'm also president of CAN Research, Education and Consulting in Corvallis.
Alan Cohn, Eugene physician. Ben Magnus.
All right, and we all know who Ellen is.
Well, I'm Peke from Mercy TV.
Right. Good. We're not going to go around the audience this time just because of time. So yeah, we should probably just get right into it. I guess the first thing, did you have an opportunity to read over the letter to Attorney General Kroger from last spring?
I've read a bunch. I've skimmed a bunch of material that you guys have sent me. So don't quiz me too hard on the details of any one letter. What I'm really here to do, hopefully today, is to hear from you as to your issues, the issues that you think are most important for me to know about, for me to kind of have on my radar. So we can kind of keep it along those lines.
Sure.
That would be ideal, and then I'll have, if at some point it becomes helpful and appropriate for me to respond to particular questions or concerns you have, then maybe we can follow up with that. Would that work for you?
Yeah, sure.
Okay, good.
Yeah.
So I'm here mostly, even though I have a microphone, I'm really here mostly today to find out, about this committee and what your agenda is, what your, not just your agenda for this meeting, but your agenda overall, and how I can be of assistance to you.
Sure. Well, we have one thing in common. We both advise the Oregon Health Authority on issues. And probably one issue that's on our mind, which is sort of an umbrella to a lot of other types of things, is your office provides legal counsel and advice to the Oregon Medical Marijuana Program. And you also provide the same kind of counsel to all state agencies, including the state police. And where we have found a lot of difficulty in the past with our relationship with the Attorney General's office has been a perceived conflict of interest between the two, because the state police tends to be fairly hostile towards our program and the patients that are protected that are supposedly protected under the OMMP. So is there, may we ask you how you may see to help resolve that perceived conflict?
Well, what I can tell you is this, and Linda can kind of chime in with me, because it's interesting. We were just having a conversation on the way over in the car about the role of Department of Justice lawyers. And you might say we have a lot of perceived conflict, because we are the lawyers for the state, for the people of the state, and for state government. And that is obviously a very broad clientele, okay, if you will. And so you could say that we have many, many potentially perceived conflicts. But I think as long as you keep the eye on the ball and you see what it is our role is. Our role is to give advice as to the law and as to what the law is. And obviously the law is not always perfectly black and white. And of course, as you know, I've been a judge before I became became Attorney General, so I'm very conscious of that and conscious of the role of the courts when we have some conflict or apparent conflict in interpreting the law. But lawyers are sort of the first line before you get there, obviously. And so it's our role to attempt to do that, to answer the questions that the agency puts to us, or if you have a question that you want to put to us that's a matter of interpretation of the law, we'll do our best to answer that and to provide you with quality legal advice and interpretation. Same with the state police and any other state agency, board, commission, the governor, the legislature. I mean, it's incredibly broad. So you're right to say that there can be a perceived conflict, but it's our job to provide high quality legal advice. And if it gets to the point where there's an actual conflict, then yes, we do have to address that.
Sandy?
When the law originally passed, I've been involved since the inception. We got a directive from the Attorney General's office to law enforcement about how they were to handle things. As time has passed, the law enforcement themselves are putting out their own directive. Is that not right? I'm wondering if we could get a directive from you, or this might be something that could come up, to direct law enforcement to what they're supposed to be doing in regard to this law. It seems to kind of slip by the wayside in the last 13 plus years.
Well, you're going to have to be more specific than that at some point. So if you don't have to be right now, but in order for us to be helpful in that regard, it may be something where we have already given some advice and it might seem like it's coming directly from the agency rather than coming from us, but it may very well have been advice that was given by our legal counsel to the agency. I'm not really sure in this particular instance because you're not giving me specifics, and I wouldn't probably know even if you were what had happened in that particular instance. But you know, we advise, the Department of Justice advises the agencies, and then the agencies act based upon that advice, right? And if we tell them that they're not in compliance with the law, then obviously they have to do something different. Or if they are in compliance, then they're going to go forward, and it may appear that they're telling you something that is not based upon having received guidance, legal guidance, but they probably have. Or if they haven't, then it may be incorrect. I can't tell you because the agencies have no requirement to contact the Department of Justice every time they have a question. It's totally up to them. We don't call them up and say, hey, by the way, don't you need some legal advice on this? Just like your lawyer would. Your lawyer's not going to call you up and say, I just heard you're doing, you're crossing against the light. Don't you know that you can only cross when the light's green? Lawyers, generally don't do that. So I'm using kind of a silly example, but the point is that that's kind of how it works with the state agencies as well, and that would include the police.
I will email you the specific things that I'm talking about. That
Sure,
will cut
sure,
to the chase.
absolutely.
Brian?
I want to be real specific with you here because I think that's going to help us.
Right.
But, and I completely understand that you haven't read a lot of the material I'm going to reference. So what I'd like to do is, from this meeting, set up a next meeting so that we can get an idea of how you're going to be handling the issues that I'm going to address right now. Would that be okay?
Well, let's hear what they are.
Okay.
I would never refuse to come to a future meeting unless you're,
that's great.
Bullying me or something like that. And I know you won't do that.
Please. Part of the material that was sent to your predecessor was a list of advice his agency, his department had given the Oregon Medical Marijuana Program concerning the promulgation of certain administrative rules. Now we know that administrative rules get their authority from organic statutes, and the scope of that authority is limited by that organic statute, and that administrative rule has to be consistent with the purpose and intent of that organic statute. And each and every one of his agency's advice on how to promulgate rules was inconsistent with the Medical Marijuana Act. It was at times hostile to the Oregon Medical Marijuana Act. And therefore, it was contrary to the law. And we listed in a letter to him, expressing a conflict of interest, several specific areas where he has done this. Law enforcement access following held the Douglas County held case, which said it's private. Law enforcement can't get at these information without a certain, without a criminal investigation being alive. And we list that in detail in this letter. How to promulgate rules to add new conditions that are qualifying. Well, there were people, there was an administrative rule promulgated with a panel that had 4 out of 7 of the members overtly hostile to any cannabis medicine benefit with marijuana. Hostile. Obviously, that's contrary to the intent of the statute that grants them authority to write that administrative rule. We just want to know how and if you're going to advise the program to be consistent with the purpose and intent of the statute that grants them the authority to do these administrative rules. We think, for example, and there's a rule right now going on about how to add conditions, we think that we are perfectly poised to be the body that makes that decision. We have lawyers, we have doctors, we have people that have been involved in the Oregon Medical Marijuana Program since its inception. We know the intricacies and the workings of the medical marijuana program better than any other body. We're created by statute.
You are the advisory committee,
Yes.
correct? So
Yes.
why don't you each tell me, if you don't mind, just a little bit about yourself and about how you view your role as an advisory body. That will help me to kind of follow up in ways that might be more beneficial than trying to respond to your question, because even though you said you were going to be really specific, you weren't quite specific enough. And I'm not asking you to be any more specific. I would just really love to hear a little bit more. I was very intrigued by some of your sort of titles and what you do, and it would be very helpful to me, since we don't have a lot of time today, to get to know you a little bit. So would that be okay? Time for me to turn the tables just a touch? And I am willing to come back. more than happy to do.
I want to start up here with Jim.
Well, I've been a patient, and I'm also on the OHSU transplant list. I've seen people over the past 15 years actually succumb because they weren't allowed transplants because of their use of cannabis, which is only done as a beneficial aid to what they're already doing. I hate to see people dying because they can't use. It's one of the things that many patients have to look forward to that's very derogatory to their own health. I also know that this agency was built to protect people from going to jail because they choose to use it. However, that doesn't seem to be slowing down much either. So I would really like to know, because when you and Mr. Holton were going against one another in the primary, many people may think that you were chosen. They like to play you as the person who's going after the drug war. I know that differently from listening to you talk at the Democratic meetings and stuff. And also that you're a person who's bound by law and wanting to protect people who bring initiatives or vote things into law. So it kind of, my question along these same lines is, are you going to institute something like that so that the patients of Oregon come first over the federal government issues that they're trying to do that are very derogatory choices? I do it because my life's over a barrel. If I use cannabis, they tell me to go and die. And I've seen many people who have done that.
And you see this as a federal, kind of a federal state issue?
Well, I see it definitely as a federal state issue, which the federals seem to be basing theirs on the law of economics, which the whole scheduling system seems to be based on doing that for the big pharmacies, rather than laws even at the federal end being made for the health and welfare of the people. As a state, I don't know why we should have to succumb to those. I mean, you know, we've been the forerunner in a lot of things, plastic bottles, you know, money and stuff. We really need to do that. seems like it's the AG's office's authority that would need to be the person saying, hey, we don't want the federal intervention yet. This is a state law.
Thank you, that's really helpful.
I became a patient in 2001. I waited 17 months to find access to the medicine that my doctor and I agreed that would most be beneficial for me. There is a serious access problem. I didn't consume cannabis at the time I became a patient, so going to the black market to access is neither safe, nor was it something I knew how to access at that point. 17 months is a long time to wait for medicine when people ordinarily pick up a prescription from their doctors. They go down to a safe place called a pharmacy. They turn that in, they get their medicine, they're able to go home immediately and begin to medicate and begin to heal and feel better. This is not the case for medical cannabis patients. There is a distinct catch-22/discrimination element going on to where, sure, you can pay your fees and you can obtain protection from the law through paying those fees, but you don't have a legal, safe access to the medicine that is best for you. That is a conflict. Part of the reason why I got involved in the beginning, my father at 82 couldn't even make it to a clinic up in Portland, living in Coos Bay, Coos County, and there were no doctors there to help him. He had testicular cancer, begging for this medicine with absolutely nothing, no availability, couldn't even get to a clinic. So we need to have this set of laws, rules, and policies governing this program work for us. We've had our fees raised and barriers continually put up. The state seems to want the revenue, but they don't seem to care whether or not enough to take the risk to take on the federal government on issues of access and that sort of thing to improve the program for the people who utilize it.
Thanks.
I've been the executive director of Mothers Against Misuse and Abuse for 30 years this year. And I got involved because I was concerned about all drugs and how they were affecting my family. When we studied this issue, what we discovered when we looked at all drugs and the death and the harm caused by the drugs, we realized that cannabis, by comparison, was very innocuous, but the harm caused by the laws was tremendous. And so we right away were concerned about those laws. But I'm all about education. We thought that if we educated people about how to evaluate every drug for its benefits versus its risk, we could help people be safer in any drug that they use. Now, I helped write the OMMA, and since it's been put in place all these years, I've played many roles. One of the things that we get to do, we have 3 clinics in Oregon, and we serve over 6,000 patients per year. That means hands-on, upfront, I'm hearing from patients who are having all kinds of problems. Some are being made to choose between access to cannabis or their other drugs. Some are dying because of that choice. Some are having to be illegal because they can't afford the new fees that have just been thrust on them. Some of them can't get the cannabis that they need, or they're victimized by their caregivers and their growers, and they can't get what's supposed to be theirs. Other patients are crazy and they're victimizing their growers and their caregivers. It goes both ways. The education isn't something that didn't come with the OMMA. And it's something that we've taken up in our own clinic, where we teach people how cannabis can interact with other drugs. And we only help people who come to us. We're not saying, come and get legal. We're saying, oh, you've decided you want to be legal. Well, come to us and let us help you. And in the process, you're going to be educated about the different forms, the onset and duration of those different forms, all the different aspects of how to reduce the harm from the use of the drug. And then, here's the law. If it grows over 12 inches, you're a Class A felon. Just that much. And all those laws that are so important that so many patients, even as much as we educate them, it's very hard to understand. So I'm all about education, education, education. I would like to do this with every single drug. And it's kind of ironic that the only drug I can get people to pay us to learn about is one of the most innocuous drugs there are. I would like to do this with methadone and morphine and aspirin. But I'm also the chair of the outreach committee, and that's an educational committee. We've had a hard time, and Tawana, if she was here, the director, would tell you how few law enforcement agencies have taken advantage of the educational program that they have for them. So for me, it's all about education, education, and preventing harm from the law.
I am all in favor of education, so we're definitely seeing eye to eye there, and I'm sure in other ways as well, so thank you.
I'm an attorney, and
We'll skip you. Let's okay. But maybe we should go to the non-attorneys first, and then we'll go back to the law.
I was just going to give a little experience about people who use medicine, but I can do that last if you like.
Okay, yeah, let's go to the doctor. Well, actually, Todd, I didn't.
It's okay. Who's the chair?
You are the chair.
Okay. Yeah, well, I've worn a great deal of hats in the cannabis industry, anything from hemp foods and industrial hemp to science and legislation and administrative advising. My favorite, of course, is horticultural research in cannabis, which I specialize in. And I wrote a bill a couple of years ago for the 2011 session called the Oregon Medical Cannabis Research Act, which wasn't able to get a sponsor the first time around. We'll see how it does this coming session. But basically what that would have done would allow the state to license research facilities to grow and possess and dispense medicine for research purposes. And the OMA was, of course, written for the patient's needs, which is great, but there currently isn't any specific allowances or exemptions for research. And that's something that I'm very interested in seeing, because what I did was I created a company, Can Research, to achieve horticultural research objectives while staying clearly within the law, and which is very difficult to do, because to achieve horticultural research objectives doing field trials, you need a lot of plants. You need a big field, which isn't very possible under the OMA and certainly under the federal government. So it's very, very challenging to achieve research objectives under the current law. So it's very important to see that changed on the state level. But I think what is the greatest hurdle to research and anything else that we're talking about here is the federal prohibition against cannabis, which always just seems to be unwavering. And so I'm very interested in hearing how you will work with to protect the citizens and the law from the federal government, and how you'll interact with Amanda Marshall as well.
Well, I will tell you that there is in the works at least a discussion that I'll be having with Amanda Marshall and with probably several district attorneys to talk about these issues, and I'm looking forward to that, because I think we need to have that conversation, and we haven't had it yet. But I intend to have to reach out to her in her role as the relatively new U.S. attorney, because I'm not really sure where she is on some of these issues, and I think it's important that at least I be aware of where that office stands and is headed potentially. So, thank you.
I'm Alan Cohn, and I've practiced medicine and clinical psychopharmacology in Eugene for 35 years. Contracted out to addiction treatment facilities, Serenity Lane for 30 years, and Lane County Jail for 35 years. I've worked in correctional psychiatry and medicine. And I also have a real interest in treatment of various pain conditions. Though it was quite a relief for my patients when the law went into effect and they could begin using medicine legally and not put themselves and their families at risk. An area that remains a concern is the Board of Medical Examiners. I guess one of the questions I was going to ask you is the relationship of your office to the board, because they have pivoted on this question and led some physicians to believe that they would get into difficulty if they prescribed opiates to individuals who are using medical marijuana, when in fact the medical marijuana allows people to use lower doses of opiates, occasionally come off of opiates, and are safer than sometimes the high dose of opiates that are required. So it doesn't make medical sense to me, and the research that I've undertaken to find out more about this question, and I was wondering if that could be explored further. Working in correctional psychiatry medicine has been a real eye-opener. The fact is there is a group of individuals with post-traumatic stress disorder who have difficulty managing their behavior in the community and with their families. They have difficulties with angry acting out behavior. Sometimes that's exacerbated by substance abuse, and they end up coming to jail. And I hear the same story over and over again from patients and from families, saying that if he's allowed to have his medicine, maybe sit around and watch TV, maybe do chores around the place, maybe sometimes go out in the community and behave appropriately, and if he's not permitted to have his medicine, he gets into discipline, he frightens the children, he breaks the law, and he ends up coming back to jail, where I end up seeing them repeatedly. And I think it's a function of their PTSD. Regardless, this behavioral syndrome seems to respond to cannabis. So an interest of mine also has been seeing how we can tailor the law for the needs of the citizens of Oregon in terms of providing best relief to the patients as well as their families and the society that they live.
So you're interested potentially in adding PTSD as a condition?
Yes.
My name is Ben Mackins, and I'm the newest addition to the board. And thank you. And I guess, in short, I got into this because my father had leukemia and had a lot of difficulties with that. And so one of the things that he turned to was cannabis. Other recommendation is doctor. And it and then he had a recurrence of a couple of different other cancers and helped during those times too. And sitting around the coffee table, he was making a decision between if he's on fixed income. And so he was making a decision because the new year he couldn't pay for it. And so we got together and did, but then I looked back on excuse me, the advisory council on medical marijuana. One of the things that they do is they advise, and they actually advise specifically, they say in there, on the decisions about what the fees are, the fee structure specifically in it, and to find out that there was no consultation with the board whatsoever. For the first time, encouraged me to volunteer and be involved publicly. And out of that rage has come a lot of peace. And part of that peace is because I get to sit in front of you and plead that I know there's a system about how all this operates, how you throw the questions back at us to kill it, how we do. We have this little dance that we do, right? And you can't answer so many questions directly, you can't do this, and because of all these dynamics that are so beyond this conversation right now. And I see all of it, I see the global perspective, and it's so frustrating because I'm such a stand to say, hey, just to be able to ask, say, hey, what are your personal beliefs on this? Do you believe this is fair? Is there something, are you willing to take a stand for us? Are you willing to take a stand for my father? Are you? Like the questions I have, I don't want to tell you about myself. I don't want to tell you about my father. I want to know that my mother isn't stressed out about if we're going to lose the property or not. because my father is running cannabis for himself. I want to know that you've got our back. I want to know that. I want to know that. And I want to know it by your actions, not your words, not your questions. And I don't want to tell you what it is. You know, everyone knows. The United States knows. The people of Oregon know, which is why they passed the law. But, as you know, we were added after the fact, and we are in essence toothless wonders. We can advise, we're all volunteers, and we do tons of work on a volunteer basis. But really, no teeth. We know, everyone knows, PTSD can be dramatically helped with it. But nothing can happen. All it is it's this dance. It's this dance for years. I looked it over all the minutes since the inception of this, before I started, every single one. And out of, what was it? I think it was 100 and some, there were just bajillions of requests and suggestions. There was like 3 that were implemented. All 4, I highlighted every one of them. It's at every turn, the goal is to just quiet us and push us in the corner. And it just doesn't work anymore. And I'm sorry to get into my soapstand. I'm just begging for your help. So
Well,
that's
I
my
appreciate
request.
And it's very, obviously, very moving. No one could not be moved by your comments, and thank you for them. You know, I don't know how many attorneys general have come to visit this committee before. Maybe they all have. Or how long have we existed as a year?
Since starting my years.
6 years.
You're the first.
You're first.
So,
Thank you.
okay. So hopefully there's a message in my being here.
Yeah.
Although I will admit that I think you invited me and I didn't invite myself. But I probably would have invited myself if you hadn't invited me. So, and you know, many of you are people that I've known now for a while. And I think the most important thing at the outset is to have trust. And hopefully there's at least some level of that. The trust doesn't just come with a title. Trust comes with actions. But to a degree with words at the outset, because that's all I can do today. There's no action I'm going to be taking. In fact, as you noticed, I'm pretty good at, you know, not turning the tables exactly, but I thought it was important to hear from you. And because it helps me to know you, and I think it will help you to understand kind of what my, you know, how I work to realize that that's important to me to know that you're not just a name, and not just a title, but that there's more. I mean, if you hadn't told me what you just said, I would not know nearly as much that can be helpful to me in informing me how I can go forward. I can't promise you anything today. I have a position that has a lot of power, but the person with the power, the position with the power, is also a person who's allowed to have compassion and is allowed to have personal views, although probably not the smartest idea to, you know, sit before you and share all my, you know, deepest, darkest, or even lightest, you know, views and feelings, because that's not my job. And my job today is to really listen to what you have to say in my role as your new Attorney General. So I'm really pleased to be here, and I thank you for sharing, because it isn't easy. It's obviously not easy to do that. So thank you very, very much. And I didn't get a chance to let Brian say his piece here. So please chime in.
Well, I appreciate that, but frankly, in my view, the best thing for us is to turn the table on you and have you tell us what you think about this program, the advice you're going to give the program on how to implement the program. Do you see it as expanding, contracting? Currently, there's an administrative rule in progress, which I assume Ms. Grims is not involved in, to determine how new conditions can be added, new qualifying conditions. We've heard about PTSD. It's obviously one of the more prominent ones. This rule that I just read yesterday that's being put forth will destroy any hopes of that. So there is something current. And when I say that you're not ready to answer that, I say that in consideration of the fact you've got a million things to do, and you've got 2 million things that you haven't gotten to yet. And so I'm not being critical. I'm really being quite understanding. I have less than 1% of the work that you have, and I'm overworked, so I can't imagine.
It's not that so much. It's just that I'm really not up to speed yet on what the specific issues are that you, A, are asking us to address, and B, whether, exactly the format in which we need to address it. And I know that sounds a little bit bureaucratic,
I think up to speed is the perfect
bureaucratisy,
language.
a word. But, clearly, lawyers, one of those. It's very helpful to us to have the question, the facts, and then we apply, the law to those facts. So it's important for me to know more specifically what the questions are. What I can tell you is what I've been saying even before formally taking office in June. There's nothing, I haven't changed my position in terms of my views, and many of you know what those are. I believe in supporting the will of the people of the state of Oregon. I've said that before, I continue to say that. And the people passed a law in 1998, right? That is going through its sort of adolescent period. Those of you who have adolescents know what I mean, or you remember when you were one. And what I mean by that is that there may be some growing pains. There may be some opportunities, actually, some opportunities here to improve the law, to improve it so that the beneficiaries of the law, those who are acknowledged card holders or those who wish to be and are able to obtain cards, have safe and legal access to their medicine. That is what I've said all along, and I continue to say that. I am not wavering in my views in that regard. That said, those are just words,
Yes.
and I understand that what you're asking for is something more along the lines of action. But there are a lot of nuances. Laws are not perfect. Sometimes laws are even designed to have some, uncertainties, which always kind of surprised me. But when I was a judge, I discovered that sometimes even the legislature would write a law and kind of leave a few things up for the courts to figure out. And so there we were. And surprise, surprise, we didn't always agree on how to interpret that law. So it's not just like, hey, this is what the law says and this is what it means. So when I hear you say, this was done, against in violation of the law, I don't know if you're right or wrong. Maybe we would differ on that. Maybe I would disagree. Maybe our lawyers would disagree. But what I can tell you is that I will act in good faith to ensure that we are following the law, and that if there should be a change, if there's a recommendation for a modification, as there seems to be here, to add a condition, that's something that, if it's within the scope of the work that we do, which I think it probably is, to at least make a recommendation to that effect, we'll take a serious look at it.
Can I follow up? I know you don't want to hear from me ever at all. But what I would like to conclude with is, at some point in time, two things to happen. One, this rule that you folks are promulgating about adding new conditions does not get promulgated until we meet again. And two, at some point in time, because we want to have input into it. If it's promulgated the way it's written now, no new conditions will be added. That's your choice. I mean, we have no authority to do anything. But that's what's a request we have. And the other is, at some point when you're ready and you've had the opportunity to review the materials, and I can't put you in a deadline, we can't put you in.
You haven't weighed in on this yet, is that what you're saying?
No, we've,
As a committee,
on the rule.
as an advisory committee.
Well, you see.
What you're telling me, I think, but let me make sure I understand, is that there's a rule that's being promulgated, and if that rule passes, it will not allow for what the doctor has suggested here today, to add a condition that he feels is appropriate. And you would like to have input into that rule before anything is formally done. Well, I would certainly think that if you haven't already had the right to have input, that you should have that right. But let me look into it to find out what the status is, so that I'm better informed in terms of the answer I'm giving you. Like I said, I have no promises today, okay?
I understand.
Because I don't know enough yet to promise anything, and that wouldn't be very smart on my part.
I agree.
So let me try to find out what the status of the proposal is, and certainly it would seem that the advisory committee to the OMMA should have the right and be entitled to weigh in on any proposed rule that would affect the law.
the problem is more that we're ignored.
Well, I just told you, you're not going to
No,
be
no, I mean,
ignored.
so when you look into it, you find out that you have 2 people on the rule committee that are on this committee,
Mhm.
and you say, oh, see, they do have input.
Mhm.
That's not what I meant. I mean, we don't have input in the sense that anything we say is taken seriously. That's what I'm trying to express.
Well, that's different from input.
That's why I meant that distinction for you.
Okay.
Because when you looked into it, you found out that 2 members of
Okay.
this committee are on that rule
So
committee.
those 2 members have provided input, but they haven't been, as far as you can tell, they haven't been listened to. Or at least they haven't been, what they've said has certainly not been evidenced to be a part of what is the rule going forward.
Which is consistent with every other input we've had on every other administrative rule.
Gotcha.
Since-
As my son would say.
And just a brief background on that, we've, as an advisory committee, we have weighed in several times on adding PTSD and for reforming the process. And myself and Dr. Cohn have been selected as members of the Rules Advisory Committee, which meets the day after our next regular ACMM meeting, which is the 13th. And so the ACMM hasn't had the opportunity to read the language, but the first draft that we received yesterday we're very disappointed with, and is a very poor starting point. So we're concerned about starting from that point.
So the next meeting of the advisory committee is what date?
The advisory committee meets on the 12th in Portland, and then September
And then
12th.
the next day is?
Rules Advisory Committee in the same room, yes. Yeah. And I was on the Rules Advisory Committee last year around the fee increase. And that was a very disappointing experience too, because the Ways and Means Committee passed the fee increase without a public hearing. And as soon as the ACMM found out about that, we immediately wrote a letter and contacted the Ways and Means Committee and said we have the statutory responsibility to weigh in on the fee structure on an annual basis, and since you're changing the fee structure, we'd like to be included in that. And they never responded, and they passed it anyway. Then the ACMM held a special meeting to address those fee increases. We came up with our own proposal, and then that proposal was also passed on to the Rules Advisory Committee, which Alice and many of us were a part of. We came up, we refined that proposal. Basically, the fee increase, what it did was it increased the fees 5,000% for the poorest and most disabled patients, because it not only removed most of their low-income discount, but it also charged them money to sign up somebody to grow for them. So if you're too disabled to grow for yourself, it costs you an extra $100 to have someone grow for you. And then if that relationship doesn't work out, it costs another $50 to change your grower. So the most poorest and disabled patients really got the shaft. And we came up with a much better proposal that would, a different fee structure that would come up with the revenue that the Ways and Means Committee wanted, while not causing all the low-income patients to drop off the program. And so that was passed by the Rules Advisory Committee and the ACMM, but it went back to what the Ways and Means Committee fee structure wanted, because there were a couple members who thought that the program was too big, and that this was also a way to decrease the patient population.
Okay,
So.
I have lots of input.
So there's your specific right there.
And I want to thank you all very much. I am unfortunately going to have to leave. The way my day got scheduled was just really too tight, and I do apologize for that. But I do feel like we've had at least the beginning of a good exchange, and I want to thank you so much for having me and Linda here with you for this nearly an hour. I am more than willing to follow up with your issues. I think that you've helped now when I read through more carefully some of the materials that you've provided, and if you want to provide others, don't overwhelm me, but I'm happy to review what you send me. It will have a better context for me, and also just putting names to faces is also always very important to me. I'm kind of a visual type, so.
I do just have
Yeah, go
one
ahead.
thing, and that is the fact that I would sincerely appreciate it if our Justice Department began to review the Oregon Medical Marijuana Act as a healthcare program and not a matter of law enforcement, which is seemingly a driving force behind a lot of what the barriers are that we face. That's all.
Thank you. Well, and as I introduced Ms. Grims to you, she is a lawyer with the Oregon Health Authority and not with the law enforcement side of our work. Yeah, I can probably take one or two quick questions. Yes.
So if we do have a legal question about OMMP or the administrative rules, what's the best way to contact you or your office for the Attorney General requests?
Well, as you know, we do have a lawyer who's specifically assigned, who's not with us today, but Shannon O'Fallon is the lawyer who's actually assigned from DOJ to review legal questions pertaining to the OMMA. So the chances are it would go through Shannon.
And would you be supervising her at all?
I'm not her direct supervisor, but of course I supervise all 1,300 employees of DOJ now.
And then specifically, my question would be, last January, Attorney General Kroger issued an opinion request about ORS 475-3232, which is the return of medical marijuana. And so the question is, does the Federal Controlled Substances Act preempt the direction in ORS 475-3232 to Oregon state and local law enforcement officers that they must return seized marijuana? Attorney General Kroger said they don't have to, in line with an unpublished federal court opinion that Brian Connolly, and that's bullshit, frankly. And I think that I'm just curious if you're getting differs from Attorney General Kroger on this crucial issue.
Well,
patients basically have a property
I think you're asking me what's my personal opinion as opposed to what my professional opinion is, because now that I am the Attorney General, so long as that is the opinion that is on the books at the Attorney General's office, that is the opinion of the Attorney General. So that's the only, that's probably not a very good, not a very acceptable answer to you, but that would be technically the answer. The answer is that is currently the opinion of the Attorney General, whether or not it was written on my watch or on my predecessor's watch.
I can tell you that I wrote a response, and I pointed out that they used a California U.S. District Court opinion on the Ninth Circuit opinion in that case on appeal, said that the return of marijuana under the Oregon Medical Marijuana Act is lawful under federal law. Those ones are
as I recall, and I have read that, as I recall, there are cases that kind of cut both ways in that issue, that preemption issue. That preemption issue comes up in lots of contexts, not just this one. And it's one that judges spend a lot of time, a lot of sleepless nights on, whatever the context is. Preemption tends to be one of the more complex areas because you have to not only evaluate federal versus state law, but you have to then evaluate the different state, opinions, state and federal
that's
opinions that
largely what I've
differ
been
from each
focusing
other.
on in my legal education. I just found the legal reasoning in this Attorney General opinion request, it's OP 2012-1, to be extremely disingenuous, just nonsensical.
Okay, well, thank you. I appreciate you raising that. Okay, folks, thank you again for having us.
Thank you, Ellen.
So you can look forward to hearing from us about some specific issues, and we'll look forward to meeting you again in the future.
All right. Thank you, everybody.
Yeah.
You have a public hearing that was held, there was a joke.
Yeah.
Which one?
Big time joke, because after they had everything, then the Mains and Needs Committee said you didn't even have to have that hearing. We haven't heard about that. I haven't heard a formal complaint about what happened there. It was so wrong. I mean, I almost quit everything after that hearing. I just couldn't stand it. You know what I'm talking about? The 3 meetings and all the court officers, the hearings officers' comments and everything, and then you didn't need to have that because we're gonna do what we said in the beginning. And that was Ways and Means, straight Ways and Means. How can that be legal? I still am just blown away by what happened at this event. And I'm asking Brian maybe.
I'm not remembering it well. I can tell you that if a law was passed with an improper public meeting laws with improper public access, and that and administrative rules as well can be overturned based on a lack of public input. But my feeble senility precludes me from remembering the specifics of what we're talking about.
Okay, what I was told by administrative staff is that after all those public hearings, the Ways and Means people came back, the 2 chairs, and said, we didn't even need to have those meetings. That's what I was told, because the prices were gonna be the way the Ways and Means set them, the way the committee set them, and the public hearings weren't gonna have any impact at all.
Well, it wasn't just the public hearings, it wasn't just the ACMM, and it wasn't the Rules Advisory Committee either. It was, after all that, they finally said, well, you have to put the fees the way we said.
Very few
You
people
don't matter,
understand
is what
what
it is.
happened there
Yeah.
at all. And I think we need to at least make sure it's entered in our minutes of the meeting. I think we need to, if we don't say what happened in a very concise way, it's just gonna go away like it never happened.
That's right.
And that's the.
That'd be a good time to-
bugging me
You can
where
get the
I'm
legislative
right.
record. They routinely give out legislative records because legislative history is a function of statutory interpretation and subject to many legal cases.
Call
So
the committee.
if you know the committee, the date, things of that
Administrator.
nature, it's on record and they're very prepared to receive requests and fulfill those requests for certain legislative records, usually taped.
Okay, it's gonna be, the staff is gonna have to be straight about what happened. Now, I'll see if they will be. Did you tell everybody about that?
Today is Annette's last day, and Tawana I didn't have time to ask her why, but so that's leaving.
She's the
been
office
her office manager
for
for
quite a while
a long
now.
time.
Yeah.
So,
Yeah.
Not bad.
Interesting. I hopefully we can bring that issue back up in time for us to try to take on the sunset clause for the fee hike.
That wasn't even considered, as you saw from all those.
Yeah, they turned that, they
responses.
blew that off too. So I think that we should at that time at least try to take down that fee hike.
Most of the
And,
78 people that sent in testimony raised the issue of the sunset clause. I'm sure everybody here read I read everyone.
Yeah.
And
And I
almost
don't
all
know,
of them did that.
what we can do, like what can be done legislatively, initiative-wise, or just having those people who did that be elected. We definitely should try something. I did have a question though for Brian, I guess would be the one. I didn't really get a chance to ask Ellen the proper authority. When back in September last year, when in particular the LV stop, the LV Musica stop and harassment there out in Ontario.
Eastern Oregon. They never heard of the federal.
They hung outside the,
Oh, yeah.
and the state troopers were involved, and they were told that they were given orders to do these things here. So I can only assume that Kroger was in the loop to say we're going to order, tell your cops to do this kind of thing, that the feds just can't come and tell the cops what to do. But the AG at least has to be in there to rubber stamp what they're doing on that. So is that correct?
That's not accurate.
No.
No, the AG did not necessarily have to be in the loop.
Okay. They could have made that, done that, and the AG
And,
could have found out post facto, much
But
less not been able
Just
to.
for perspective, that's not a question for Ellen.
Oh, okay.
Even if the AG was in the loop, she wasn't the AG.
She doesn't, yeah, okay, she's definitely not a chain of command of the state troopers and all, so.
But she does advise the state police, just like the AG, whoever that is, just like they advise each and every agency.
Okay.
But like she said accurately, every agency doesn't seek their advice every time they do something.
Sure.
Which is
Well,
kind
if
of
they get
odd
what they
for
want,
our
they can keep
particular
using that and
agency,
applying that, sure.
Because our particular agency seems to ask them each time, whereas they can promulgate these rules and help the Medical Marijuana Act.
Right.
They don't necessarily need to involve, Shannon O'Fallon in every step.
No, well, they
But
obviously.
that's obviously, there's something going on there that, that inhibits them from acting without the consent of the Attorney General, which might give you all the impression that that goes on in every other agency. But I don't think the state police asks the Attorney General for much of anything, because they kind of run their own agency. When they wanted to not return medical marijuana, they got the Attorney General to write an opinion contrary to the state of the law. It ignored Ninth Circuit and went to a district court, which means that the case they cited was overturned. And the Ninth Circuit actually said Oregon's law is written in such a way that the immunity granted by the Federal Controlled Substance Act exists under Oregon law, does not exist under California law. I can go into much detail about it if you want, but they were very clear about it.
So are we gonna have to wait till another case then?
Which
before
is
we-
why the Oregon Court of Appeals allowed the return of marijuana in my case. Because the state made that same dumb argument. And the Court of Appeals said, no, that argument doesn't fly. In Oregon.
So that thing though,
But that's unique. They only did that because they wanted a particular result.
Sure.
They could go to the court and say, here's the
Right.
Attorney General's opinion.
So, yeah,
Otherwise, they don't
But-
go to them typically for every move they make.
So how are we gonna get that revisited? How are we gonna get that changed? Do we need, does another case need to come
Well,
up?
I have a
and then-
case, I have a case in the Court of Appeals now.
Okay.
But it's mostly because of an Oregon Supreme Court case that came down, that they're trying to say, it's called Emerald Steel, and there's some people who want to read it as though the Medical Marijuana Act doesn't exist anymore. The Court of Appeals is waiting to see what there's some other case in the Supreme Court that they think is going to answer that question. But barring the Emerald Steel being interpreted that way, the question of whether or not to return medical marijuana is well settled.
Good.
In fact, in that case, the state conceded that the marijuana should be returned, the one I have in the Court of Appeals now, and the county sheriff intervened and said, well, I'm not going to do it. The state of Oregon has said, return the marijuana. And then the state of Oregon Attorney General said, it's illegal to return the marijuana. It gets so convoluted with this stuff. It's so simple. It's a simple, innocuous, harmless plant, and it's produced these mountains of chaos.
Yeah.
That's too bad.
And we have 300 patients in Southern Oregon that need their medicine back from last year's raids.
That's the feds, though.
I know.
Well,
Probably not gonna get it.
Oh,
They're
they
gonna-
won't get it, but.
there's
and we
nothing
de-
I said should be heard as though it has any effect on the feds at all
Absolutely.
whatsoever. No.
Absolutely.
This is
When
just-
M80 passes, and the feds come back and channel it, try to do an injunction, is the Attorney General gonna be involved with
Yes.
that at all? So.
If you remember were you here with the Death with Dignity Act?
Yes.
Oh, right, sure.
Yeah, the Attorney General up there defending the Oregon law.
Okay.
Was there explicit
As it
language in Death with Dignity? Because M80 has explicit language
Right.
about the Attorney General defending it. Did Death with Dignity have explicit language? Or did the Attorney
I
General?
don't think it needs to. One part of the Attorney General's job is to defend Oregon law. So when I go into court and I say, this statute is unconstitutional, the Attorney General has to be notified and have an opportunity to appear and defend the statute. That's just by basic, they generally do come in to defend the statute as part of their job.
Okay.
They're not supposed to take a position because their job is to defend the statute.
Right.
So they're not supposed to take a position against medical marijuana, so their job is supposed to be to defend that statute.
And when
They don't
M80
quite do it so
No,
much.
no,
with
that's we'd like,
marijuana.
sure.
The Attorney General should have been in there defending the Oregon statute that says return the marijuana.
Right.
That's his job.
And what M80 also does is make sure that that the funding for the Attorney General's defense comes from the OCC revenue. And I guess that way the Attorney General can't really pick and choose you know, how they're going to spend their
Well,
their
that's an
budget.
interesting
So
twist there, guarantee it.
gives them a bucket of money to.
Cool. Well, I want to thank all the ACMM for coming out and doing this stuff there. I did want to let Todd know that I want to talk to some more about submitting the addition for the PTSD. Think very seriously about go ahead and putting in the petition now, just to have that there.
Not now. No.
Well, I'm afraid this, you know, either it.
It's not going to get worse. But I would. But if it gets turned in now, it's going to be denied.
Okay.
And if you turn it in later, it might be denied. But
Well,
a
it
better
kind of sounds
chance.
what's going on now. We're going to screw with the process so we don't have one, and that way we don't have to bother come up with excuses to deny it. So it sounds like their plan now. I mean, you guys are trying. We saw that article that's out there. It's very encouraging, but you know.
Well, yesterday's editorial wasn't that
Wasn't
encouraging.
What editorial was that?
From the Oregonian,
Yeah.
What did he say?
either.
basically saying that there's no medical evidence for PTSD. If a hearing came up today, then there would be a bunch of patients that show up and say it's cool and.
So why don't you turn that dime on them and say, well, then here's my bill for research, and given your statements in your editorials, we believe we can count on your full support to try and get this passed by the legislature so that we can have the research that the Oregonian editorial board says that we so desperately need.
Yeah, I'm happy that they recognize the importance of relying on science for this.
So
but
by ignoring all the science that's out there currently.
But throw your bill at them and say, we want your support on this now.
Yeah.
But this science is politicized because you have any scientific study of marijuana for medicinal purposes has to go through the Institute for Drug and Addiction.
Yeah.
And they will only allow protocols that go for either the addictive or harmful effects of marijuana. So they politicize the science, and when they say let's rely on the science, it's really an easy out. Because the science is polluted by politics.
Sure.
It's not
The process,
a
just like-
scientific process. It's not a scientific analysis.
So something that would be important
I
for,
think
for,
the
for
way
the
to
rule would
respond
be
to it is support
But
our troops.
correct me if I'm wrong.
Because, you know, we've had more than 20 years of war, 2 10-year wars. We have an enormous number of troops coming home with an extremely high percentage of PTSD. And if you really, no matter how you feel about the wars, America is united about supporting our troops.
That's right.
And this is the way that we can support our troops. Because if you don't have the science, you look to the troops. They've sacrificed their lives, they've given themselves up for this country, and you want to say, we don't believe you? That's awful. That's not supporting the troops. I think that's the tack we have to take.
If your bill were to go and get passed, right, and then NIDA stepped in, would it not be her job to sue them and say, well, we've passed this bill here in Oregon, we're going to do our own research, and you need to, you know, and argue with the feds?
You're going to commit a federal felony by possessing the marijuana.
They're going to commit a federal felony if they allow dispensaries. They're committing, all of us are committing federal felonies every day.
That's right.
But in the same sense that you can't defend the medical marijuana statute against the Federal Controlled Substances Act, because we are committing felonies, well, you are. But the feds don't seem to care about it. If the feds choose to care about it, and believe me, science that's designed to promote the benefits of marijuana is something they're going to care about, then they'll prosecute the felony.
I want to ask the community, we are talking a lot about PTSD, and of course it's very timely, but when the original petition was out there, we had anxiety, depression, insomnia, severe agitation, and PTSD. I still think that all those things need to be considered. And actually, when you look at the depression, anxiety, insomnia, those are kind of part and parcel of PTSD. And I'm just wondering if we're walking away from the other conditions, or are we wanting to just have a process in place that would allow any of these to come forward? I just want to kind of get an idea of how we stand as a
Are the PDSI, are they different than the PTSDs?
I don't know, what's that?
The distinction seems to me, and you can probably speak to this better, but there is a distinction in that you can have PTSD as a result of being in war, but you can have PTSI as a result of being in war. That's typically what it's assigned as, but PTSD is any post-traumatic stress, like you see your boyfriend's head get blown off in a robbery attempt, or
You're
you know,
abused as a child,
yeah,
those are the
abused as a
people who showed up
child.
for that
Right.
hearing.
So that's where the PTSD comes in, and they've started at the veterans level to redefine it as PTSI,
What's the
For the veterans.
which is PTS injury.
It's an injury.
And
not
Jim,
disorder.
we complicate the issue and to our own detriment by using anything but medically approved terms. And the only medically approved term at this point in the DSM-4, going to be in the DSM-5 next year, is PTSD. When we bring up other letters, it frightens some people because they don't know what they mean and they're not specifically defined and not consistently defined. And it brings up political and emotional factors that take us away from the focus of just trying to get a condition approved. So it may be a very valid classification, and
But
it
not
may be important for
recognized.
some people to call it that. But if we want to work in the political and legal system, we have to use a language that everybody agrees upon. Otherwise, we create a discussion that takes us away from what we want to accomplish.
So in volume 5, do you think they're going to make that distinction, or will it remain as PTSD?
You know, I honestly don't know, but everything that I've heard so far is that it's going to be still PTSD, but it is going to be classified a little differently, and there's going to be qualities about the condition that have been made more specific, and at the same time, certain aspects of it that are broadened. So I think there'll be some changes, but I don't think PTSI is going to be in there.
That brings up a question that you might know an answer to, is that if we pass it to where PTSD is an approved condition and PTSI becomes a condition, will veterans qualify?
Well,
Or PTSD, could it be a cross diagnosis? Could you diagnose someone?
I think that's going to be a legal question, but the fact is, I think anybody who's diagnosed PTSI by a concerned and caring physician would be willing to give them the PTSD label for that purpose.
All righty.
Thanks, Todd. Thanks, guys.
Thank you all for coming.
Right, welcome everybody.
Guys and gals.
See you all on the 12th.
In a couple of weeks.
Thank you. Mercy TV. You want to say anything before I turn it off, Glenn?
Yes, good night.
Good night. God bless you all, every single one of you.